Think we actually got a picture. Yes, we got a picture. Hello, everybody. Hello, Mr. StreamYard. Hello, Frank. Hello, John. Hello, Chad. Hello, Matthew. And hello, Matthew. Hello, Renee. And hello, Matthew again. Greetings to everybody out there. Good morning. Happy Saturday. Happy weekend. Happy fourth quarter. It's the fourth quarter. We're not even talking about football. So I'm doing my weekly update, and then there was a bunch of questions that popped up, and so I'm going to talk about those too, and hopefully that will kind of bring everybody up to speed. Before I start, of course, not legal advice. Please like, subscribe, and share. And I'm going to preface this by, if we're obviously we're talking about GTII today. For those of you who don't know about that, there was an action against Alpine. There was a case that was in Nevada in federal court. SEC sued Alpine. I guess they found against some of the officers, but no remedies have been imposed. And I guess there's a hearing in November. I will follow up on that to give you a better summary of that. But other than Alpine and those scumbags, we're talking about GTII, and you can kind of repeat the same. So before I get into what I'm going to discuss about GTI today, briefly, I told my girlfriend she draws her eyebrows too high. She seemed surprised. Let that sink in a little bit. Have you heard the joke about yoga? I know it's a bit of a stretch. What do you call a nose with no body? Nobody knows. And why does Snoop Dogg use an umbrella? For drizzle. Of course. And last but not least, at least in this round, never confide in a vacuum cleaner. They're always collecting dirt. Please don't use those. Don't use those, please. No. So before I go on to what I wanted to talk about, what I wanted to talk about was since somebody just asked me a question, I saw a question on the board. It's by Matthew. He asked, and I'm just going to deal with this one. Let me put this up on the screen. He asked me this question. He's asking about the trading of the shares, and he's asking, why was that many shares traded? I didn't see it, by the way, and I don't know if that's in the United States or outside the United States. I don't know who's trading the shares. I have obviously, and that's kind of lead me into one of my points. I've obviously asked the receiver to try to stop the trading. I have no idea what the receiver has done in that regard, because the receiver has not responded in a professional manner, I would say. And again, let me bring everybody up to speed. So, obviously I have my issues with the receiver, but I still don't want him to be removed at this point in time until he completes his job. And whatever concerns I have about his counsel that I've expressed, they're still working forward. And again, I'd rather everybody stay on board, at least for the time being, to get the job done correctly, and we watch and oversee and make sure they do it correctly. And that's kind of what we're doing. The bad guys, I think, would want the receiver and counsel tossed out and nothing replaced, and a vacuum left, a bankruptcy filed probably, and then get out. So I'm kind of careful here because I have criticisms, obviously, about the receiver, and I have questions and etc. You've heard them many times, but we don't want that position completely vacated because we don't want the bad guys to win, and they want to win. So getting back to the question I think it was Matthew asked about the 138,000 shares, and I've asked for the receiver to get the stock to stop trading. So now I'm going back to our last live stream because I went through and I kind of read my basic correspondence and emails with the receiver's counsel. I'm going to quickly go over it, what the receiver asked, what I said, and then what I think is kind of a dickish response. And as a matter of fact, I decided not to. I decided not to do this video. I was going to say the title of the video was going to be, should the receiver change his name to Dick? And you'll see what I'm talking about. And since that question about the shares has been put out there, it's kind of a relevant question. So I'm going to read it to you. So going back in time, so I asked the receiver what caused the receiver to respond, and he hasn't responded to much of anything I've sent out there, but be that as it may. What I asked the receiver is basically, can you go ahead and stop trading, try to stop the trading in the US and see what you could do elsewhere? And if you can't do it by the exchange, then go to the court and ask the court to block it. So his response was, and I'm reading this, and this was sent on September 26th at 8:06 a.m. Pacific time. Walk us through this if you could. What would you hypothetically do to achieve this? What specifically would you do? What regulatory or self-regulatory agency would you contact to achieve this? And remember, I mentioned that if you can't contact the regulator, then contact the court. It seems to skip over that, like a lot of other things. What documents would you file, or whom would you petition to achieve this? And once achieved, how would you get the company back to fully trading again? What specific documents would you need to be filed to achieve that goal? What level of surety could you provide to shareholders once you started trading would resume again? Do you have experience in these problems? Now, I've maintained that I'm not a securities lawyer, so why he was asking me these questions, I didn't know. I would think those are questions that he would be asking a securities lawyer. In fact, I would think that he would have already met with a securities lawyer since he had hired one, I think in Texas. At least that was the representation. And these are questions that he should have asked and should have gotten a response to. And if the response was, we can't do it, then the response to us shareholders should be, can't stop the trading. If they could stop the trading, then they should announce on what basis. So he asked me a bunch of questions about how would you do it? Even though I say I'm not a securities lawyer, his response is, well, how would you do it? He has a securities lawyer, so I don't know why he's asking me, but he does. And I respond, my response, I say, how do I respond to that? I'm not a securities lawyer. So first thing would be to hire a securities lawyer expert with experience dealing with the OTC and with delisted stocks. I believe you hired a securities lawyer in Texas. I tried him a couple times to no response. So that is the person who should be leading that charge. If the securities specialist who you hire does not know how to deal with the company in the instant situation, I would hire someone else who does. Kind of disconcerting that a year after the receivership was set up, that now you're asking me these questions. If I did not or could not hire a securities lawyer, then I would contact the OTC and transfer agent and see if they would voluntarily stop trading temporarily per stipulation. Notice temporarily is in there. I would do the same with the transfer agent. If they agree, the problem will be solved in the US. If they don't agree, I would go to court in Nevada and seek an order directing the OTC and the transfer agent to cease trading GTII. After getting a stipulation and order, I would go to the Canadian SEC equivalent and show the stipulation order and see if they will voluntarily cease the trading. If after exploring this and perhaps the SEC, if you cannot limit the trading, disclose the fact. That is my off-the-top suggestion. So he's asking me, I'm not a securities lawyer. I kind of, off the top, I say, hire somebody who knows what they're doing. If they don't, hire somebody else. If you can't get satisfaction through the OTC, then try through court. As far as I know, they've never tried anything through court because I haven't seen any filings. So what's his response to this? So he asked me a bunch of questions that he should have asked to his securities lawyer, and he should know the answers to. I then respond, and what's his response? So, and we didn't talk about the response. I was annoyed when I received the response, but here's what the response. Richard, and I'm glad we're on a first name basis. Paul, the receiver's SEC counsel is not authorized to speak with you. Thank you for acknowledging you have reached out to him. We will seek to address that. So remember when I said he should change his name to Dick? So here he's using my statement that I contacted the receiver's SEC counsel like a year ago. Somehow that was inappropriate. Now I later corrected him because he was, I think this was a gotcha moment, says you shouldn't be contacting counsel. And I later sent him an email saying, yeah, I contacted him, I think in late 2024 and never communicated with him. That was it. And I haven't tried since. So, but that was kind of in my mind, that was like the words, we will seek to address that. Seek to address what? Dick? I haven't contacted them since you announced that, which is probably late 2024, and it was perfectly appropriate. Never had a conversation. He never provided. I don't even know what he's doing, by the way. I have no idea because none of your reports indicate anything that the your counsel, your securities counsel, if they still exist, what they're doing. I have no idea what they're doing. I have no idea what they're doing with regard to any potential transaction. I have no idea what they're doing with the OTC. I have no idea if they know what they're doing as to the OTC. I have no idea if they know what they're doing as to the delisting. But the receiver, either named Paul or Dick, I don't know what his name is, he apparently is concerned about contacts that occurred when he announced the name of the SEC attorney for whatever reason. Probably should spend your time responding to other more important things, Mr. Receiver, Paul or Dick, whatever your name is. So that's the first response. He implies somehow that my contact a year ago was inappropriate, even though I didn't speak to anybody, and the receiver and the attorney didn't speak to me, and I haven't reached out since. But okay. Number two, I've asked the hypothetical questions in the. So this is, I asked a bunch of questions. I said, stop the trading. He then throws out a bunch of questions that he should be asking his securities lawyer, not me. I respond and I basically say, ask your securities lawyer. And if he doesn't know the answer, find somebody. And if that doesn't work, go to court. And his response to that is, I have asked the hypothetical questions in my previous email in response to your suggestions of seeking a halt to trading of GTI as a test of your situational awareness and knowledge. What the hell does that mean? Is that responsive in any way to anything I've ever asked him? In any way? Isn't that more just like a non-responsive nonsense from this guy? More non-responsive waste of time, as opposed to saying that we've tried it, I've contacted, it didn't work, it's gonna work, it's in process. No, I'm just trying to figure out what your situational awareness is. What kind of nonsense? What kind of nonsense is that? Then three. So again, in response to my question is, stop the trading. His answer is, three, I've learned all I need to know. Thank you, Paul. That's his response. So that's his response to stop the trading, and my saying find somebody who could do it or go to court. This is his response. I think that was pretty pathetic. So we hadn't talked about his response, so that was the response he provided. I have no idea what he's talking about. Again, I think this is a gentleman who takes things very personally, and he's concerned about his own well-being sometimes. That's my thought process. I think he's concerned about his own well-being more than the well-being of shareholders, but that's just my opinion, and so be it. So I yesterday, and I continue to ask questions to the receiver's counsel. So I've dealt with the receiver and the shares. I've asked him, he hasn't responded. I invite any other shareholders who are concerned about the stock trading to ask the receiver and the receiver's counsel why it can't be stopped, and to explain why it can't be stopped, and hire, if they don't have someone who's familiar with that process, to hire somebody who's familiar with that process. And ask also what the attorney in Texas, whatever his name is, I don't know his name, what he's doing, because I have no idea what he's doing. All I see is I see a post by Forrester indicating that he hasn't heard from the receiver in many weeks at this point in time, and there's no reference to this Texas council, so I don't know what's going on there. All right. So yesterday I sent out another email, and I sent out regular emails to the Receivers Council asking questions. The last one, just to give you an update, because it's going to relate to the next point I'm going to raise. Good morning. My understanding was that the receiver would be summarizing and presenting all the claims that were filed. I believe by the way, either that was said in court or it's in a pleading. So there was a court hearing and they were establishing the process by which claimants, parties that have claims, creditors against GTII could make a claim. And I believe, and I'll have to look through the paperwork, the filings, or the hearing itself, that I think it was Dylan who said that the claims would be summarized by the receiver, and then they would make, and then that would be presented, and so we'd be aware of what those claims were, and then the receiver would make a decision, and then the court would either agree or not agree or set up a process. So yesterday I sent it out to Dylan and to the Associated Council. Good morning. My understanding was the receiver would be summarizing, presenting all claims that were filed. I believe the cutoff date was 11/15, but I've yet to see the claim summarized. Please advise. Thank you. So I'm waiting for the summary of the claims. I believe, and I heard that the number of claims that were presented, and I'm going to get into this because it seemed to be an issue, at least I saw an issue raised last night. I think there were 8 claims that were raised. At least I saw the number 8 somewhere. 8 claims. Though at least one involving Bronx Eye Care, they asked for an extension of time. They being I think the receiver and Bronx Eye Care, and apparently they came to some agreement on the Bronx Eye Care claim. Apparently, I have not seen it, but that's what the filing suggested. As to the other claimants, I do not know what the claims are. That's why I've asked again for the summary. And I do not know what the position of the receiver is as to those claims, whether they're going to be paying any claims, but I expect, because it was either in the paperwork or they said it in court. I don't remember which one, but I expect to see a summary of the claims. And once we see the summary of the claims, then we will be able to kind of decide ourselves whether these are meritorious claims or not. All right. So I'm asking them, please advise, thank you. And then at the bottom, I say, P.S. Any update on the status of the audit? Any update on any further depositions? Thank you. And that was sent yesterday morning at 8:35 a.m. Pacific. I did not get a response. Perhaps they're busy. I hope I get a response. I expect to see the claims summarized. I don't expect, because they have not, I've asked, status of the audit, but anybody else who feels interested in the audit, you should ask and reach out also. Any update on further depositions? They haven't responded that way. It may reflect that there's negotiations ongoing with certain parties, settling certain. So this would be different than so we have 2 things. One is the monetary claims, one is shares, and one would be perhaps claims against the officers and directors for damages. Those 3 different things. So the claims that we're talking about here, that I'm talking about today, are third parties making claims against GTII because they claim they have some deal or something. So perhaps, and I'm making up a situation, but we enter into a deal. I agree to give you palm trees, and you agree to give me 1,000 shares. That might be a deal. Now you're trying to enforce that transaction, or that same transaction could be, I'm going to give you 100 palm trees and you're going to pay me $10,000, and you didn't pay me the $10,000. So, but we have 3 different things. We have those claims that are presented by third parties against GTI. We have the disputed shares claims that are in process. And then on top of that, we have any additional claims that might be made against the officers and directors. So they had a fiduciary duty to all the shareholders. You could pursue actions against that. Now, the issues in all of this come down to money. Is there enough money to pursue all these things? You have to kind of just pick and choose, whatever. But what I'm talking about now just are the claims that are made against GTII. And I'm told, at least I was told at one point in time, there were 8 or so. And one, again, has been negotiated. And the question about the depositions, I was talking about, are they negotiating any disputed share issues with some parties? That very well may be the case. And if they negotiate a resolution of disputed shares, which also will have to be approved by the court, then that might dispel the need for deposition. And maybe that's why they haven't announced any further depositions yet, but I'm just speculating completely. But they, as of now, they haven't responded to the audit depositions, the summary of the claims, nor the cutoff date. And if any of you have questions about that, you should respond also. Now, so that's dealing with the claims that are outstanding that were supposedly submitted by 11/15. November 15th was the cutoff date for those claims. And so last night I saw on X, I think it was on X, there was a discussion about the proof of claim document that was submitted was submitted with a cutoff date in November 15th. And the way it got started, I think, was somebody asked and they were curious, and they asked ChatGPT a question. It was either Grok or ChatGPT. And I don't know what the specific question was, but it was about the proof of claim. And the problem is with all those particular sources, I don't think you can trust the conclusions unless they're not 100% trustworthy anyway. So if I use it in court, I have to disclose the fact I'm using AI so the court knows that and reads it differently. They're not 100% accurate, and they hallucinate. They kind of pick up stuff. But the bigger problem is the questions have to be precise. And that's the problem in doing legal research. So, this is a very complicated issue in terms of the proof of claim, etc. So it really depends on what you ask Grok, even if it was 100% correct. And I'll just give you an example. So let's say I wanted to ask, who does the proof of claim form on the GTII website, who does it apply to? I would have to ask Grok and say, with regard to the lawsuit, case number blank, 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 filed in Nevada involving White Rocks versus David Reichman, and all the pleadings, please review all the pleadings, and in particular, the proof of claim form. And after reviewing the proof of claim form, describe how this might impact shareholders. I think it really has to be that detailed a question. And I just kind of made it up off the spot. But you really have to have not just a general understanding. So could you ask about proof of claim forms? You could. I just think it's going to lead you nowhere and not provide you detail. So some people thought that, were thinking, and maybe they're correct, and I urge them, if they have this belief, to go and check it out otherwise. But they believe that this proof of claim form, after asking ChatGPT and Grok, they thought that somehow this relates to shareholders asserting their share ownership. And if you have concerns about that, because some people seem to have concerns based upon asking ChatGPT, then what you should do is you should contact the receiver. And I think I sent out an email this morning to the Receivers Council on this, but you should contact the Receivers Council, and express your question to them. But, in my view, and again, this is just my opinion, pure speculation, I looked at the form, and I'm familiar with the process because I heard the process. And, perhaps the form is just terrible and is misleading and doesn't do what it's intended to do. But clearly, in my view of this form, and I'm just starting with page 3 of the form, just to kind of give you an idea. So some people thought that this might have to do with shareholders. I think this clearly has to do with creditors of GTII. So anybody who claims they have a right to be compensated out of the receivership assets because of some prior relationship with GTII. And why do I say that, besides the fact that that was my understanding, period, and that there's been no notice, no claim form to shareholders requiring shareholders to attest to their ownership? I guess the closest thing that occurred to that is when the plaintiffs filed the lawsuit, they had to attest to some type of ownership. I think there was a verification or a declaration that was submitted, which I did also at that time. So those people verified the share count, but that was not a claim form. And I've not seen any claim form. I've not seen any disclosure. I've not seen anybody say you need to do this to assert your claim. But if you have a concern about that, then you should contact the receiver and the Receivers Council to let them know. But getting back to the form itself, so why do I believe this claim is for creditors and is about money and not about shares? Well, I'm going to start with, so I'm going to go through quickly. I'm going to go through 1 through, if I could find it, on page 2. We start with general instructions, and it says you must answer every question, and this is the claim form. Who is the person who's answering it? If you're answering on behalf of somebody else, who is that? If it's answered on behalf of an entity, who's that? Current address and telephone number of person completing the form. So far, I'd say it's neutral as to about being shareholders. Current address if it's an entity. Provide a mailing address, and here's where the form begins. Item number 7. This kind of what leads me to believe that this claim form is about creditors' claims and not about shareholders' shares. Number 7, how much is the claim with a money sign? Include an itemization of the claims. Does this amount include interest or other charges? What is the basis of the claim? Is all or part of this claim secured by a lien on receivership assets? Has a claim been acquired from somebody else? Do you know if anyone else has filed a proof of claim for the claims you are mentioning above for money? Have you filed or otherwise commenced any lawsuits, arbitration, actions, or other proceedings, or made any demands against any person or entity about that claim? And that's it. And sign it. So, besides the fact that my understanding was this about third-party creditors' claims, besides the fact that was discussed, and besides the fact the document says that, if you don't believe, and I don't mean to belittle anybody, I just think it's pretty clear that it's not about it, but that's how it appears to me. And if you see it differently, then don't hesitate to bring it to the attention of the receiver or the Receivers Council. Don't rely upon me or my thought processes. I'm just looking at the form. The form seems to be pretty clear, but maybe the form is not as clear as I think, or maybe you just want to feel good. Maybe you just want to sleep better at night. So as to anything, if you have concerns about that, reach out to the parties that have the knowledge. But it seems to me it's just a claim form. And when I mentioned there were 8 people, it was 8 people apparently. Maybe it's more, and maybe it's entities. When I say people, entities is like a corporation or a partnership. They exist, so they can file things also. So it's 8 of those apparently. Maybe there's more that have come in at the end. But at September 15th was the deadline, as to the Bronx Eye Care, it was extended because they're working on a resolution. But that's what the claim form is. So if there is one for shareholders, perhaps there is. I haven't seen it. I haven't seen a notice. And also, I'm not, myself personally, I'm not concerned about it. But people have different levels of concern. So if you have level of concern, then follow it up. So we talked about summary of these claims. We talked about trying to stop trading and the response of the receiver, his lack of response, his failure to say why he could not or could, if he was not. You heard questions about also the status of the audit, status of any depositions. Haven't heard anything new about that. Again, my speculation about the audit is perhaps the SEC is involved, and the reason why the audit has not been released perhaps is because the SEC has told them not to release it because they're pursuing or considering pursuing relief against some of the officers and directors. That's a possibility. I don't know anything specifically about that. That's pure speculation on my part, but that at least would explain the delay. So hopefully we will get some answers from the receiver to the questions I put out this week at the Receivers Council. Hopefully I'll get some information about things moving forward. If there's negotiations that have been ongoing with regard to the return of shares, at any point in time, we could hear something about some type of purported resolution. If there are, I expect the summary of claims to come out very soon, so we'll be able to review those also. In the meantime, until the audit's done, I don't think we can do anything. But I would expect the audit to be done any moment. If it's not done, and hopefully if the SEC is holding it back, hopefully that won't last much longer. Hopefully the receiver will be able to provide more specific information. And I think that's it. I mean, there wasn't a whole boatload of information, more the issue about the question about, the claim form, the issue about the trading that I saw, the issue about the audit that still remains unclear. I've seen posts from Mr. Forster and indicates he's still waiting to hear anything. Haven't heard about any other pending transactions. I'm expecting some kind of update from the Receivers Council. I would tell the Receivers Council, as opposed to putting out a 40-page report, you don't need to repeat everything that's been done in the past. If there's some new information, just post the new information in 2 or 3 pages that are easily read, and don't waste the trees and our attention by doing something 40 pages nobody really could follow, because that's just the point. So I'm expecting that, because now we're in fourth quarter. I think somebody was told, even though I don't get a lot of response, I get response from other shareholders. So I think somebody mentioned that they were promised that the fourth quarter that they would hear it. I don't understand, by the way, that how either the receiver or the Receivers Council, even in his response to me, why he's reaching out selectively to people and not posting things for everybody. Just more of my bitching about the way that things are done. That's it. Let me take a quick look, see if anybody has any questions that I see. You missed the bad jokes, yes. Although I have a couple to just finish off. Yeah, I know all this stuff is, and I have tons of emails with the receiver and the Receivers Council. If nothing else, again, I have no concern that they're not going to do the right thing. I'm just staying on top of them to make sure they do the right thing, and everything's, properly documented, so that, if there's any questions, it's there. I'm sure they have responses, and etc. So there was a question. I think there was a question. I don't see the question. Leighton, I didn't see the question. But anyway, just to end out this session, this is kind of relevant. Why did GBT fail art class? All it could do was draw conclusions. I asked ChatGPT for dating advice. Now I'm single, but I got a spreadsheet. Do you know that ChatGPT tells better jokes than my dad? Of course, my dad is no longer with us. I asked ChatGPT to tell me a dark joke. It just dimmed my screen. And last but not least, I asked the shop attendant for deodorant. He asked if I wanted the ball type. I said, no, I wanted the underarm type. Anyway, hope you all have a great weekend and be well. And if I hear anything, I will obviously update you. I'm sure there'll be new information next week, even if it's or updated information. I don't know if it's new, updated information, and we'll speak then. Hope everybody's well. Take care. Hi, Jack Hamilton. Anyway, be well. Have a great day. Have a great weekend. Hope your football team wins today and tomorrow, and be well. That's it.